I want the court to know that I filed this public record.
I'm not going to get into this back and forth on who's bad faith or who's not bad faith. So stop. Okay. State of Nevada versus William Errico, case number C307611. Counsel, please note your appearances for the record.
Good morning, Your Honor. Christina Wilder, bar number 13616.
Good morning, Your Honor. William Terry appearing in reference to the criminal case.
Good morning, Your Honor. Jackie Nichols on behalf of Real Party and Interest, Las Vegas Metropolitan Police Department.
All right. Anybody else? No one else. All right. Very good. All right. This is a continuation on, I'll need the title. Continuation of the hearing on Real Party and Interest, Las Vegas Metropolitan Police Department's motion requiring the defendant to comply with NRS Chapter 174 on order shortening time. I continued a week because Ms. Wilder, who was the author of the request, was not present last week. And Mr. Terry, the motion was filed in the criminal case against Mr. Errico, in which Mr. Terry represents him, and Mr. Terry appeared last week and indicated that Ms. Wilder is not a part of the criminal defense in this case, and the request is not being made on behalf of the defendant for purposes of the criminal case. Mr. Terry's position was that, in view of that, the public records request should be handled separately from this criminal proceeding. We stopped it pretty much at that point in time. Let me first turn to Metro. What's your position?
Thank you, Your Honor. First, I'd like to ask if you received a copy of my reply that I filed yesterday afternoon. If not, I can touch base on that.
All right. I did receive a copy of the reply, but I will be frank, I didn't really have a chance to. Well, wait, no, I did look at it. No, I did not have received. I'm looking at a different reply. I don't show it in my stack of materials, a reply. Go ahead and touch on it.
Judge, not to
Sure.
interrupt.
Hold on, Mr. Terry wants to say something.
Not to interrupt my colleague, and I know the court said Metro should be allowed to address the court first. My position is that if the court ultimately rules that this is a Chapter 174 matter, I'll consider doing what I need to do under Chapter 174. But I take the same position that I did last week, which is this is a completely independent matter, and I'll abide by whatever the court's directive is.
And I understand what you're saying, Mr. Terry, but I want to hear what Metro has to say.
Understood, Judge, but if I'm consistent with that position, what I'm asking the court to do is issue whatever type of order you want. I am not a party to this matter on the criminal case. You don't see J.P. Rahman here. You don't see the DA here. No. So with the court's permission, I'd like to leave the courtroom and let the parties argue it out, and whatever the directive is of the court, I'll yield to it.
Well, you've been here for a few minutes. Why don't we wait just a few minutes longer and let's see where we are.
Very well, Your Honor.
All right, go ahead, Ms. Nichols.
Thank you, Your Honor. So while this is a public records request by Ms. Wilder, it's important that the court recognizes that it was on behalf of defendant Errico in relation to his criminal proceeding. That's the most important fact here. So while I understand that Mr. Terry is his criminal defense attorney, the arguments put forth by LVMPD is that defendant Errico cannot bypass the criminal discovery statute, hire another attorney to do so via the Public Records Act. And in our reply, what is essentially brief is that there is case law that supports that even though an individual, whether it's defendant Errico on his personal behalf, whether it's Ms. Wilder on her personal behalf, or the media, they may submit a public records request to the department for various records. That's not in dispute. And when a requester is denied access to records, a requester may seek judicial intervention to get access to those records. There's nothing in the Public Records Act that prohibits the department from seeking relief in a criminal proceeding where the criminal proceeding is open and the records being sought specifically pertain to that criminal proceeding. And again, more importantly here, it is the defendant in this case that's seeking access to those records. And so as demonstrated in the initial motion and in the reply, it's the department's positions that the records sought are not public records because of the pending criminal proceeding. But the department does inherently recognize that defendant Errico, because of his status as a criminal defendant in the pending criminal case, may have an interest in these records. And the proper mechanism to get access to those records is through NRS Chapter 174. So it's the department's position, based off of case law that we've cited in our reply, including Don Ray of Nevada, which is a Nevada Supreme Court case, that says when there's a pending open criminal proceeding, those records may not be public records. And that's the position that we're taking here, Your Honor, because these are communications. The biggest issue here are the communications between the department and a third party, specifically in relation to William Errico. And in that sense, the department has represented the only communications that it has in its possession today are communications between the department and the district attorney's office, which the department takes the position those would be subject to a subpoena, and then the defendant would have to meet the subpoena requirements of articulated by the Nevada Supreme Court. And the other issue is that Ms. Wilder does concede that these records are being sought for the criminal proceeding. That's the other issue that's at stake here. And so what the department is simply seeking, Your Honor, is that if defendant Errico, whether through his attorney, Mr. Terry, or through his attorney, Ms. Wilder, he cannot bypass the discovery rules set forth in NRS 174 to get access to records that he may not be entitled to under 174 by way of the Public Records Act. That's all the department is seeking here, is basically an order from this court to say defendant Errico, which this court has jurisdiction over the defendant, over his criminal proceeding, to say if you would like these records, you have to utilize the subpoena process. Does the court have any specific questions for the department?
I want to turn to Ms. Wilder. Ms. Wilder, are you acting on behalf of Mr. Errico?
As far as the public records request goes, that's correct. And I would like to address what Ms. Nichols has said because I believe much of it is improper. And if I may be heard, Your Honor, the first part is really what we need to focus on that Ms. Nichols mentioned. And she said 239 vests the requester with the right for judicial action. Again, that is the requester. And she has given no articulation as to how LVMPD has authority to even file a motion in this case. And I want to make that very clear that the right to judicial action is a recognized property right that Mr. Errico has. And for this court to interfere with that right, it would constitute a taking and it would further be improper. Two other things that Ms. Nichols mentioned was regarding the jurisdiction. And I do want to point out, and I noted this in my opposition, that LVMPD has entered as a stranger to the case, that they have come into a criminal court, and that they are, and I want to point out that they did so after failing to serve me with a copy of their motion, and after sending me an email saying that they were gathering records responsive to my request. So this has been a lot of bad faith on the part of LVMPD. And then the next point that I do want to make, well, I don't want to waste the court's time as far as if they agree that there is no jurisdiction, which I have argued in my opposition as well, that they don't have the right to come into this case as a stranger to the case, which is a non-party to this case. But if the court is going to entertain their motion, then I would like to point out that these records do fall within the public records realm. And specifically, LVMPD made these records public records through testimony by their own officers. And so if the court needs to hear more about that, I can go into that, but I don't want to waste the court's time if it's ready to rule on this based on jurisdiction.
All right. Anybody else have any comment? All right, not hearing anything. Okay.
I'm sorry, Your Honor. I'm sorry, Your Honor. I'd just like to clarify one thing. This motion that the department has brought forth is strictly, and any order by this court would be strictly limited to the records sought in relation to William Errico. The request, the initial request submitted to the department contained 18 other requests, or 18 total requests, some that do not have any relation into William Errico's criminal case. And so in that context, the department is not asking the court to do anything with those requests. It's strictly limited to the requests related to the criminal proceeding. So while I did contact Ms. Wilder saying that the department is working on some other requests that do not pertain to William Errico, the motion brought forth to the court is strictly related to defendant Errico and his criminal proceedings.
And I would like to respond to that. I want the court to know that I filed this public records.
I'm not going to get into this back and forth on who's bad faith or who's not bad faith. So stop. Okay. Listen, let me just ask Ms. Nichols. So essentially you're saying as to the materials that we're dealing with here today, in terms of materials related to Mr. Errico, the only things you've got are records of communications between Metro and the DA's offices in regard to the criminal case. Is that what you're saying?
Yes, Your Honor. In response to her request for communications in between LVMPD and a third party, the only records the department has in its possession are communications between LVMPD and the district attorney.
Okay. All right. Well, here's in terms of the issue of whether Mr. Errico can make a public records request or not, I do think that just because you're indicted doesn't mean that you can't make a public record request. Now, the fact that you are indicted and there's an open criminal case does affect whether or not certain records are public records. And generally, records related to the criminal case are not public records and are available only through the general discovery rules that are provided for by statute. So the long and short is Metro, I do think Mr. Errico can make a request for public records, so I'm not going to rule that he can't do that. Metro, as it's done here, has said we have certain records, we don't have certain records, and what records we do have we feel are not public records because they are concerned an open criminal matter. So the Metro, I think, is totally within its rights to do that. Then Mr. Errico can seek subsequent judicial review of the public records request if he wants to do it. But the issues of bad faith and everything is to Metro and its records. The long and short, Metro says it doesn't have the records. That sort of ends the issue. I'm not going to get into whether or not this impacts in any way on Mr. Errico's criminal case because Mr. Terry represents him there, and he says that none of this is being done for the criminal matter. So I'm looking at it purely as a public records request, and it has its impact on the criminal side. I'm not ruling in any way on the public records request. What I am saying is I do think Mr. Errico does have a right under the public records law. I don't think you lose that because you become a defendant. But I think it does necessarily change the nature of certain records. And those records with communications between Metro and the district attorney's office as it relates to this case probably are not public records in view of the pending litigation. And so Metro can refuse that if Mr. Errico feels that he's got some basis to go beyond that and wants to have some formal review of the public records response, he can do so and file whatever's appropriate in that regard. So that'll be the order of the court. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
To clarify one matter,
Sure.
if the dispute between Metro and Ms. Wilder continues, it should not be, documents should not be filed under the criminal case number. It should be filed pursuant
To the
public
statute.
records.
Right.
And if somebody's going to prepare an order in this regard, I'd like it to state that.
All right. Well, I'm not sure if anyone's preparing an order, so I'll leave that up to. Does anyone want a formal order, or are the minutes sufficient?
Your Honor, this is Jackie
Your
Nichols.
Honor,
I believe a minute order is sufficient.
And we're satisfied with that.
Your Honor, respectfully.
Hello? Somebody just.
Your Honor, respectfully, so are you saying that if there is an issue regarding what LVMPD gives to my client, that I'm supposed to file it in a separate court, not here, even though the court's ruling on it today?
That's essentially, I'm ruling on the motion and saying, that I do think he has a right to file it, and so if anything, but, Metro has the right to say they don't have the records, and they have the right to say they don't feel that certain records are public records. They certainly have the right to do that. If they assert that, then you feel it's wrong, then you have the ability under the Public Records Act to take additional legal action.
Okay, thank you, Your Honor.
And thank you, Your Honor.
All right, thank you, everybody.
And thank your staff, Judge.
Oh, thank you, guys.